a very warm welcome again to everyone. It's great to see you here for what is our last 3CL lunchtime seminar of Lent. It is not the last 3CL event because there's one that Louise, who is also with us, will moderate. Louise, as you know, is the 3CL co-director. And then we've got the roundtable highlight at the end of Lent on Friday, 12th of March at 2 p.m. So we are not done at 3CL, but this is the last 3CL seminar, lunchtime seminar. And we are very pleased and delighted to have with us Professor Markus Roth from the University of Marburg. He is a professor of civil law, labor law, German and European commercial and business law, and that means he knows a lot. But I would say that he is, without exaggeration, a specialist for corporate governance, and that is what he will speak on today. His topic is German corporate governance after Wirecard. Markus was a senior research fellow at the Max Planck Institute in Hamburg, which is a research institute for comparative and international law from 2002 to 2008, and then became a professor in 2009 at Marburg. I personally met Markus when I was also at the Max Planck Institute in Hamburg, and that was 15 years ago. Markus was never clearly allowed me to disclose this, but I'll just do it. You know, we became friends there and discussed corporate governance and other things. And that's why I'm particularly pleased to have you here today with us, Markus. Markus has probably written the treatise on directors in German law, which is, correct me if I'm wrong, a 2,000 or 2,000 page book. I'm not sure if it's one book or two books, but it's a lot. And so I think we can safely assume that we are good hands as regards corporate governance. But he's not talking about you know, necessarily the law in the books, even though he writes them. He's talking about the law in practice, and we are very much looking forward to his presentation. Markus also has some connection to Cambridge. He was a visiting fellow at Wolfson College, and his other research interest is the law of the elders, so how older people deal with and are dealt with the law. Now, before I hand over, just to invite you to questions, you're very welcome to signal that you're interested to ask questions. I understand that some of you have dealt with the Wirecard scandal in your lectures. So please do feel free to ask questions. We'll roughly have a half an hour presentation and then followed by questions. I'm aiming to close this session at 2 p.m. sharp. Do enter, you know, do signal your interest to ask either in the Q&A or in the chat function. We will then elevate you to the panel so that you'll be visible and you can speak and ask your question, and please do use this opportunity. That said, Markus, thank you very much for taking the time and telling us about German corporate governance after Wirecard. I'll hand over to you.
Oh, thank you very much, Felix, for this very kind introduction. It's a great pleasure and honor for me to be here, at least virtually, back in Cambridge. I had a great time. And well, I'd like to present you some things on the German corporate governance and especially the Wirecard case. I will give a short introduction, then have three major parts. First, go a bit deeper into the Wirecard case and some German legislation around Enron. I'll highlight the relevant corporate governance principles in the Wirecard case and go on to show a bit the current reform agenda in Germany and make some additional proposals I'd like also to discuss with you. Briefly, I'll sketch a wider picture for corporate governance reforms in Germany. The Wirecard case isn't alone, and also very briefly have a look at the European level, since there are some proposals seeing Wirecard as a trigger for the capital market union. I'll conclude then with a few theses. Well, to introduce what was Wirecard. Wirecard was a German payment provider which collapsed last year since it turned out that trust accounts of 1.9 billion euros, which were supposed to be held at Philippines banks, did not exist. Wirecard was for years a German tech code, but since its beginning accompanied by rumors, among other due to ties with dubious business like the online gaming industry. Wirecard was in the blue chips index, the DAX 30 from Germany since 2018, and in 2019 it was the most valued German financial group with a market capitalization of 20 billion euros, more than Deutsche Bank or Commerzbank. To the collapse, there were critical reports in the Financial Times, well, there were also some other problems, not only in the company, but also in the supervision. The German supervisory agency, BaFin, banned short selling on Wirecard without thorough investigation the fraud, which was later discovered. Therefore, the head of the supervisory agency, the BaFin, Hufeld, declared to decline, announced to step down early this year. And also the auditor EY is very harshly criticized and due to testified in the investigation committee of the German parliament this month, before there was some legal dispute whether it's possible for EY to make this public appearance. The focus of my presentation won't be at the auditors or supervisory agencies, but I'd like to go a bit deeper into the internal corporate governance. Therefore, with the first part, I'd like to give some details of the Wirecard case. It would be a day or more or weeks to discuss about that, say a bit about why Wirecard was possible after the enron legislation emerged in the US and also in the European Union. Well, Wirecard was founded as Wirecard with two words at the end of the last century, and it was profitable at least according to the audited accounts since 2005, with steady rising revenues and returns. I will show that afterwards. In 2001, it was first bankrupt since notebooks of the later managing directors Brown and Marsalak were stolen and could not be retrieved with important data of the company. Then there was an insolvency buyout by an erotic holding company, which had some need of online payments. Merged with another listed company in 2006, and already 1 year later was introduced into the tech DAX, the German new market, and in 2018 in the DAX 30 in the blue chips. There were some rumors in Germany during all these times. In 2008, there was a block, and after that, short selling by representatives of the German Association for the Protection of Small Shareholders. And the supervisory board asked EY to make an investigation. EY cleared the management and since then audited the accounts of Wirecard. 2 years later, there were other allegations and short sellings, and these similar accounts, which gained international attendance, were the Satara report in 2016, and also a series of investigation reports in the Financial Times. Well, according to the annual reports, Wirecard was very prosperous with steady rising revenues and earnings. The EBITDA was about 30% of the revenues, and it was a success story looking at the books. But some doubts might appear if one sees that liabilities rose even more than the revenues and also the cumulative EBITDA. Therefore, it's not clear since when there was fraudulent behavior at Wirecard. I mentioned the rumors. What were the acting people? In the center of this crime is Jan Marsalek, the COO, which is supposed to have flown to Russia, to Belarus, and maybe later was turned to Russia. He's a fugitive. Markus Braun, the long-term CEO, you see the terms here, is in custody. And was in custody was a long-term chief financial officer, Burkhard Ley, for several months. And in 2020, then James Rice took over, Harvard lawyer, which then uncovered the fraud. It's not clear to what extent the CEO was part of this fraud scheme. The accounts and the revenues, the profits were made in Asia, and this was the domain of Marsalek, the COO. Braun himself portrays him as a betrayed visionary, but there are doubts, and the prosecutors don't believe him. And also his successor had another impression. He stated in an interview of the Handelsblatt, the German Financial Times, that within 1 hour he realized that it was fraud. He criticizes its predecessor, Markus Braun, very harshly, and says it's difficult to believe that the alleged €1 billion fraud was not noticed over many years by him and the auditor EY. Well, to coming to my point, the role of the supervisory board as a first line of defense for uncovering fraud, hindering and uncovering fraud. I have to make some assumptions because it's not really clear what happened. My assumption is that there was no active role of supervisory directors in the fraud. There were 3 long-term directors who were the only directors for several years. But I think also they did not detect or became aware of the wrongdoing. And I'd like to highlight some German corporate governance feature why this might be possible. Even a further supervisory director who quit due to insufficient corporate governance standards, Tina Kleingart, declared that she had no actual clue that there was wrongdoing, but she declared that she could not stand these corporate governance standards. In 2019, a former managing director of Deutsche Börse was appointed supervisory director, and then led a process which ended in the insolvency of Wirecard. Well, is Wirecard a German engine? There are some signs for that. The prosecutor's office accuses the managing directors I mentioned on professional gang fraud, breach of trust, misreputation, and market manipulation in several cases, and stresses that in the interrogations, a strictly hierarchical system characterized by esprit de corps and oath of loyalty to the CEO as a leader is reported. Therefore, there were clear signs that there was something wrong with the corporate governance and also accounting fraud like an Enron. While Germany had also some pre-Enron reforms due to corporate scandals in the 1990s, since then the supervisory board mandates the auditor, and there are stricter reporting duties of the management board, and this is the role model which German academics also have in mind, that it's the primary role of the managing directors to inform the board and not other people. Post-Enron legislation did not come up with mandatory audit committees, and also some reluctance towards independent directors, also due to German co-determination. But even there are no independence requirements for audit committee members. And the reluctance toward direct contacts between supervisory directors and employees of the company is also due to a provision in the German Stock Corporation Act, which excludes the supervisory board from managing the companies, and states that measures to be taken by the management may not be transferred to the supervisory board. Well, what are the relevant corporate governance principles? It might be odd, but it has to be discussed whether this kind of two-tier system facilitates wrongdoing. And I like to go on to the special features of the Wirecard Supervisory Board, give an international overview on the Supervisory Board to the Netherlands and Austria, and conclude with some remarks on audit committees, accounting and supervision. Well, does a two-tier system facilitate wrongdoings? This is somehow strange, since a supervisory board has the original task to monitor the management. This was historically derived from the partnership limited by shares. And in the first years of German stock corporation until the 1930s, there was a possibility to give the supervisory board additional competences. But in the 1930s, managing director primacy was introduced as a legal transplant from the US with respect to the general meeting, but extended to the supervisory board. And this concept of managing director primacy was further extended after World War II in respect both of shareholders and supervisory directors. The majority view is that contacts to employees interfere with management and should therefore be exclusively assigned to the management board. Internationally, this is not everywhere the case. There is no such exclusion in the Netherlands. Well, to the special features of the Wirecard board, there were three, like in the management board, three members which were a long term, which have long terms, and like in Lehman, there were also quite old bankers, you see that the board had only three members until 2016, and afterwards two members quit quite early. In Germany, there's a 5-year term for supervisory directors, and they quit after less than 2 years. The size, which might be surprising, having in mind that the pattern in Germany is that boards are too big due to mandatory co-determination, but you see that there are also quite a fraction, 40%, of the DAX 30 companies having a board of 6 or 12 members. And this correlates also with other legal forms, not German stock corporation, but European companies or partnership limited by shares, and also Linde as a limited from Ireland, which is also a part of the DAX 30. Small boards are even more common in other indices of Deutsche Börse. The MDAX, which are the medium-sized companies, and the TechDAX, the technical companies, shows that there are in the tech DAX, nearly half of the companies having such small boards with only 6 members. Well, if one takes a closer look to the supervisory board members, there is also some lack of expertise. 2 of them, Matthias and Henseler, were bankers, had experience in the banking industry, and one was an investor, Klaus, son of a former Austrian president. But none of these long-term directors held positions on the management board of a listed company or was a supervisory director at another listed company. Of the 2 newly appointed supervisory directors, first all were women. 2 resigned within the first 2 years of a 5-year term. And then the former managing director of Deutsche Börse, Thomas Eichelmann, was the first supervisory director with a background in the management board of DAX 30 company. Well, this is one critique. Another critique is the lack of independence, not only due to long terms, not according to German corporate governance standards, the term were too short. It's had to be more than 12 years. Concerning director remuneration, you see that there's a large fraction until 2015 of performance-related remuneration, and it was assigned to revenues, since if there were more revenues reported, supervisory directors were better paid. And the allegations on Wirecard were, at least in the last years, on inflating revenues. Therefore, there was no clear incentive for supervisory directors to decover the fraud. There's also another questionable practice in the supervisory board of Wirecard that call these long-term supervisory directors were also directors of a subsidiary, the Wirecard Bank, which held the banking license. And you see that also quite a fraction, more than 60,000 euros per year were paid to this chairman of the supervisory board, a long-term chairman. Due to this work at a subsidiary, the annual reports disclosed that as a related party transaction, but the pattern didn't change until Wirecard filed for insolvency. Concerning the other long-term directors, the pattern's the same. Well, what might one say about the supervisory board in international comparison? If you look at 2-tier systems, there are 2 other nations to be named: Austria, which requires a mandatory consent for supervisory of the supervisory board since the 1980s, and already mentioned the Netherlands, where supervisory directors are not excluded from management, and the Dutch company law might be of more importance for German companies, since a lot of German biotech companies are incorporated according to Dutch law as namenlose Vernootschaften, CureVac, which also will produce a vaccine, hopefully to cure COVID, Kiagan, but also others like Airbus. Concerning the access of the audit committee to employees, while the Dutch payment provider Etienne might be referred to according to the terms and references of the Etienne's audit committee, each member of the audit committee has access not only to all relevant books, but also the authority to interview officers and employees of the company to the extent necessary or useful for the proper performance of his duties. At Wirecard, there was no audit committee at all until 2019. And when the audit committee was installed, first there were 2 long-term supervisory directors at this audit committee. And it's not really clear what this audit committee did after it was installed. And Eichelmann replaced Henseler. And well, it's besides this questionable audit committee, the accounting practices were questionable. EY did qualify the trust accounts as cash in the balance sheet of Wirecard, and there were failures in supervisions. And as I mentioned, the presidents of the German supervisory agency and also of the audit regulator had to step down. While to the current reform agenda in Germany, there is a reform by Deutsche Börse concerning the index regime, and there's also a draft governmental act on financial market integrity to strengthen that. This draft Financial Market Integrity Strengthening Act will make audit committees mandatory for listed companies and other public interest entities, PIs. And for PIs, there will also be the need to have 2 financial experts at the supervisory board. In these boards, there shall be granted access of the chair of the audit committee to the head of internal control and the head of risk management, but a duty to inform the management board without delay. Deutsche Börse reformed its index regimes, also making audit committees mandatory, however, with a grandfathering clause for existing companies, and the index companies has to form their audit committees in compliance with the recommendations of the German Corporate Governance Code, which has some additional features. Further aspects are the independence and access to other employees, but that's not touched by the draft Financial Market Act. There's no independence requirement for audit committee members, which is international standards in the act. Concerning internal control and risk management, the draft Financial Market Integrity Strengthening Act builds on the accounting directive and provides that listed companies will have an internal control unit and also risk management system. Further proposals are to make also compliance management system mandatory and to transpose the whistleblower directive earlier. Well, to come back to the access of the supervisory board to employees, I mentioned that many scholars are reluctant to grant the supervisory board direct access to employees, and the draft Financial Market Integrity Strengthening Act only provides access to the heads of internal control and the risk management system. However, the 2-tier system does not hinder that such contacts to employees. I stressed the Dutch code, and there are also other nations using the Dutch model. In Italy, a lot of large companies are listed and also incorporated according to Dutch law. It's Stellantis, Ferrari, and with a 2-tier system also ST Microelectronics, and they all provide that direct access. The Dutch Corporate Governance Code itself refers to officers and external advisors, but gives room to more. And to improve for growth companies, the internal corporate governance, the board as a whole should have the competence to set up a policy for communication with employees and advisors of the company, and the management board should be obliged to ensure reasonable access of the supervisory board to employees and advisors of the company. Concerning independence and director remuneration, the German Corporate Governance Code since this year recommends that half of the shareholders' representatives are to be independent. However, the code should also recommend that half of the members of the Audit Committee are to be independent. Since practice mirrors co-determination in the committees and also in the Audit Committee, and there might be an interest of controlling shareholders to have deeper access to the financial situations, there might be a need, like the SEC did this after Sarbanes-Oxley, to declare employee representatives as being independent directors. Until now, performance-related remunerations and payments by subsidiaries are not named to hinder independence, but I think they should indicate that the director is not independent. Concerning the terms, it's important to know that German supervisory directors are appointed for a 5-year period. The Governmental Commission for the German Corporate Governance Code proposed for the last reform, which is now to be applied by the companies, a 3-year period, but this was denied by practice. Now proxy advisors might address this, at least Klaus announced, to look at this 3-year period. Furthermore, there should be some kind of succession plans also in the German corporate governance system to counteract the emergence of groupthink, which is quite obvious, I think, also concerning the supervisory board in the Wirecard case. And this groupthink is more likely if there are parallel terms for a long time, like in the Wirecard case. The profile of supervisory directors should be based on the ambitions of the company, not on current revenues, and therefore I think that the board was not proper in its consistence. Concerning the auditors, there are also provisions in the draft Strengthening Financial Market Integrity Act. The rotation every 10 years is now to be applied of the audit regulation. The member state option is withdrawn in that respect, and also in the respect of the separation of audit and device. There are proposals to give stricter standards for auditor liability, a cap of 16 million euros for listed companies raised from 4 million, and no cap for liability in the case of gross negligence. Now its intention, and also some stricter criminal liability. The supervision is also strengthened. The competences of the BaFin are to be improved and to check annual reports independent from supervisory authorities of the auditors, which was a problem in the Wirecard case, since the auditor supervisory had no adequate personnel at hand. Well, what else is the wider picture for corporate governance reforms? Shareholder communication and is a theme in Germany, also due to the exclusion from managing the company. Shareholder communication is restricted by many in practice and academia to the exclusive competences of the supervisory board, such as nomination and remuneration of managing directors. but there should, at least in my view, also be the possibility to discuss the strategy. And I think this will be of more importance if the green revolution will take place. Germany will have to transform its industry, and I think it's important to have supervisory directors having a significant and a role in this transformation. For this, also shareholder proposals might be facilitated. Non-binding shareholder resolutions are not allowed, at least according to the majority view in academia, and therefore denied also in practice. Well, why a reason why academia was very long, very reluctant towards direct contacts to employees, the strict regime for supervisory directors, liability, according to the German Federal Court of Justice, there's no discretion in the monitoring context for supervisory directors, therefore a strict liability. And therefore Markus Luther called it the opening the boxes of the Pandora. If there was access to every employee, because without any discretion in the monitoring context, that would raise the risk of liability for supervisory directors, and that would be counterproductive. The duty to act of the supervisory board therefore should be aligned with the standards established for the business judgment rule, and therefore there should be action needed only when the supervisory board may not reasonably assume that action is not needed. This would solve this problem. Well, last part, very short, the European level might Wirecard be a trigger for the Capital Market Union. There is a report by Katja Langbucher and others which recommends to a committee of the European Parliament to introduce a structure similar to the European Central Bank with direct competences over a substantive number of listed companies. Therefore, there might be a system of financial supervisors with the European Central Supervisory Agency. This proposal was initially also taken by the German Ministry of Finance or the minister, but maybe also due to elections this year, he no longer stresses that. I think a rationale for doing something like this is a competition also with US stock exchanges. You see a picture of BioNTech, which is also producing vaccine in Marburg. And they are not listed in Frankfurt, but only in New York. And the same as with CureVac, another biotech company, due to produce such vaccines. Besides such a structure, there might be some common rules on corporate governance. Since Germany refrains from using member state options, there might be some common rules on audit committees and independence. However, this has to be named with some question marks whether it will happen or not. Therefore, I'd like to conclude. The draft Act on Strengthening Financial Market Integrity provides for mandatory audit committees with 2 financial experts for public interest entities. And for listed companies, there will be the need to establish internal control units and risk management systems. However, this is already the writing in academia. I'd like to propose some further regulations to strengthen the internal corporate governance. There should be at least a possibility of direct access of the supervisory board to employees, and an obligation of the management board to provide access to obtain adequate information. This might counteract and erase, and maybe some doubts might be handled with that. Audit committee members should be independent, at least the majority of them. This is something for the code, and also for the code that performance-related remuneration should be a criteria to deny independence. Shareholder stakeholder communication should be facilitated, and also shareholder resolutions for corporate governance and sustainability things. Seems Wirecard might be a trigger for the capital market union. This goes beyond the German corporate governance, that's European corporate governance. It might be included into some further action of the European Commission, but that's not clear. The Parliament might move on with that. I think what is really upon takeout is that there should be a more prominent role for growth companies in the German corporate governance debate. You saw that there are a lot of small boards, which are a new pattern. And for growth companies, there's, in my view, a need for minimum standards, but also for flexibility. And one might not be that sure that two financial experts are really a need for all listed companies. I think for big listed companies, that's correct. But the growth companies should be more in the view of the corporate governance scholars and also practitioners. Well, thanks a lot.